we have the last speaker in this session, and it's Associate Professor Mia Rönnmar. And she will give us a presentation of Anna Christensen's research. And I think you have done that before when it comes to her festskrift. I think you were the author when it comes to that part. So please, the floor is yours.
Thank you. The aim of my presentation is to introduce and reflect on the challenging and multifaceted and still, I argue, coherent development and characteristics of Anna Christensen's research. And this is achieved through a discussion of some of her major works and writings. Her doctoral thesis, the book Disqualification from Unemployment Benefits, the book Residential Right in the Tenement House, and writings on the theory and European comparative social security law. I will give a brief account of these different works and writings, and of course it is utterly impossible to do justice to Anna's research in a short time, and in addition many of you were her friends and colleagues and followed her during much longer periods of her research career, so you all have your own recollections and reflections, and I have taken on this assignment with both great humbleness and great affection. Anna studied law at Stockholm University and then carried out her doctoral studies at Uppsala University, where she defended her thesis in 1970. And this picture was taken in Uppsala and kindly brought to our attention by Professor Jonas Malmberg from that precise university. And in 1975, Anna Christensen was appointed professor in civil law here in Lund at the Faculty of Law, and became then Sweden's first ever woman professor in legal science. Anna's doctoral thesis, Studies in the Law of Sale of Goods from 1970, dealt with some problems concerning the right to treat a contract of sale of goods as discharged, the right of rescission, in various situations which may arise in the course of performance. Not only this doctoral thesis, but also, I argue, Anna Christensen's research in general was always characterized by ambitious and detailed legal dogmatic studies. However, despite a clear basis in general civil law and a principally legal dogmatic orientation, this doctoral thesis was all but traditional. Already early on, there were signs of Anna's independence and individuality. She clarified, this doctoral thesis was not a monograph, which was and still is the dominant tradition in Swedish legal science. These were 4 different chapters dealing with different legal problems that could be read independently, but they were also linked together. According to Anna Christensen, parts of the system of remedies within the law of the sale of goods were based on antiquated perceptions, and new solutions had to be found. After her doctoral thesis, Anna Christensen came to focus on the parts of the legal systems connected to the welfare state and the everyday life of women and men, such as labor law, social security law, and housing law. And this book, The Disqualification from Unemployment Benefits, Avstängning från arbetslöshetsersättning, was a study of the Swedish rules on disqualification from employment benefits on the ground of refusal of work or other self-imposed unemployment. Benefits granted by the unemployment insurance scheme could be withheld for a specific time or for an indefinite time if the claimant refused to accept employment offered to him by a public employment exchange, if he had quitted employment without good cause, or if he was not at the disposal of the labor market. The main purpose of this study was to disclose the control and the steering of citizens that was built into the Swedish social security system. A social security system is not only an instrument of redistribution, I will return to this point, but is also an efficient behavior steering instrument, not only by distributing rewards, but also by applying economic sanctions. Anna Christensen researched not only the substance and the meaning of the legal rules as they appeared in legal practice, but also the way in which the rule enforcing organization operated. This was an impressive and ambitious study covering a large body of case material derived from all levels of the rule enforcing organization, both court judgments and decisions by authorities. And Anna also subjected this case material to a statistical analysis. So this study represents actually another shift in Anna Christensen's research towards more theoretical, social science-oriented and critical approaches. It started out as a basically legal dogmatic study, albeit with a greater emphasis than usual on case law and practice from lower courts and governmental authorities, and then turned into a critical social science-oriented study of underlying ideologies, revealing the role in the system played by the employment exchange offices. At this level, the legal rules operate only as a frame within which the job service and the individual placement offices can act freely in relation to the legal system. According to Anna Christensen, there were strong interests on the part of the state to conceal the role that the job service plays in the system. The state had an interest in concealing how the behavior steering and repressive functions of the social security system are inseparably associated with the supportive functions of the system. This is contrary to the ideology surrounding the welfare state. And Anna also revealed how a very common feature of these disqualification rules is the lack of regard to the rule of law in the sanctions directed against the weakest groups. In the book Residential Right in the Tenement House, we can see the importance put by Anna Christensen on historical and normative developments. The theme for the study was the security of tenancy and the residential right in the tenement house, and its normative content was traced back more than 100 years, inter alia through a very close reading of discussions in the preparatory works. Likewise, in her article Protection of the Established Position, a basic normative pattern, Anna traced historical and normative developments in family law, labor law, social security law, and housing law. Anne Numhauser-Henning has already described how Anna Christensen in this study took her first steps towards creating the theory of law as normative patterns in a normative field. The aim of this study was to reveal underlying norms constituting society, and Anna Christensen explained how the rules on security of tenancy had developed in a field between two normative poles, one being the right to property of the owner, and the other being the residential right in the tenement house. And if you read the book, Anna says that this demonstration of the normative kinship between the right to property and the residential right in the tenement house was one of the most important conclusions following from her study. The content of the residential right coincides with the conservative element of the right to property, and Anna Christensen found that history, also normative history, repeats itself. We've already heard a lot about the theory of law as normative patterns in a normative field, and since we are under a bit of time restraint, I will not go into this theory anymore, apart from saying that this theory was created, the creation of this theory coincided in time with the creation of the Norma research program, and with focus on normative developments within the social dimension of the EU and of the European integration. In the mid and late 1990s, Anna Christensen displayed a growing interest in European comparative social security law and took part in different comparative research projects at the European level, and some of you here participated with her in those projects. Trends towards internationalization, globalization, and European integration generally increase the need for comparative legal research, And Anna's theory of normative patterns in a normative field is a very fruitful device in conducting comparative research. Discussing developments as movements in a normative field of law helps to overcome existing and sometimes even considerable national differences at the legal technical level. And according to Anna, the theory constitutes a common theoretical framework that makes it possible to, and now I quote, emancipate law from its confinement to the narrow boundaries of a national legal system. And Anna Christensen herself used the theory to analyze Swedish and European social security law, including the EU coordination regulation. Central to Anna Christensen's understanding of social security was the fact that it developed as part of the industrial society and must be understood as a complementary and dependent system to wage work. At an aggregated societal level, social security supplements wage work and its distribution of resources. Social security provides protection and maintenance in situations when a person is unable to earn a living through wage work, owing to sickness, old age, unemployment, or childbirth. Anna argued that social security law may appear as a very technical area, but actually there is a very strong connection between general patterns in social security law and general moral and political values in contemporary society. And in this respect, Anna Christensen also pointed to the fact that although only some areas of law are usually called social, really all legal rules are social in the way that they emerge in a social process and constitute a kind of social convention. And all legal rights, she argued, are also social, since they arise and receive their forms in social relations. Anna Christensen insightfully and creatively analyzed legal regulation and normative developments in European comparative social security law in terms of normative patterns such as basic subsistence, replacement of lost earnings, accumulated entitlement, and market functional pattern. And I'm sure that we will have the opportunity to return to these basic normative patterns in the following 2 days to come. Anna Christensen was, apart from being a legal researcher, also a very important voice in the public debate, not least as a long-time columnist in the Swedish daily newspaper Dagens Nyheter. She was a personal, critical, and important voice. And in 1999, Anna Christensen was awarded the prize Frihetspennan by Torgny Segerstedt's foundation. And I think that their explanation, which I have taken the liberty to translate myself, expresses it perfectly. Anna Christensen is, in a quiet and effective way, courageous and moral. She distinguishes the structures of injustice. She is a well-articulated eye-opener who clear-sightedly refuses to be drawn into the trendy and the politically correct. She stands for justice. And I also think that her role as a columnist influenced her legal writing because it enabled her to write clearly and seemingly simple about very difficult and important things. And I remember her red scribblings on my paper saying to simplify. Some concluding remarks. It's all clear that the theory of law as normative patterns in a normative field is perhaps the most influential legacy of Anna's research. But I hope I've also been able to, in this very brief time, to show to some other trends that ran through her research as a common thread. Critical, social science-oriented and interdisciplinary approaches, but also not to forget these very detailed and ambitious legal dogmatic studies and the interest in the historical and normative developments. And in the preface to the Liber Amicorum that we presented Anna with before her retirement, Anne wrote that Anna had a unique ability to identify fundamental and principally interesting legal conflicts. You could talk about an absolute pitch for normative conditions and relations. And in this presentation, I have chosen to focus only on Anna Christensen's research in terms of published works and writings, but of course her influence and prominent position is also very much reflected in, for example, honorary doctorates from universities in Oslo and Copenhagen, and also a great influence that she conducted in legal science by way of supervision of doctoral students, several of them present here, also in participation in Nordic courses for doctoral students in social law, legal theory, and labor law, and as an inspirational role model for younger colleagues. And this is certainly true for me. And discussing law with Anna meant always transcending academic hierarchies. So on this very personal note, I close my presentation.